The Federal High Court in Abuja has granted the detained leader of the indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, what it described as a final opportunity to open his defense in the long-running terrorism trial instituted against him by the federal government of Nigeria. Delivering the ruling, Justice James Omotosho, who presides over the case, firmly cautioned that failure by Kanu to present his defense on or before November 7, 2025 would lead the court to declare his case closed, thereby forfeiting his right to further arguments or evidence in the matter. We had adjourned till today for the defendant to put in his defense or be deemed closed, but I am bound to give him another opportunity, Justice Omotosho stated. If he does not, I will deem him closed. I know that he is an economist and not a lawyer, so I will give him this last opportunity to put in his defense. Failure to do so, he will be deemed closed, the judge added. The stern remark underscored the court's growing impatience over the pace of proceedings, which have been repeatedly stalled by Kanu's refusal to open his defense, claiming there are no valid charges against him. Prosecution seeks closure of Kanu's defense. Earlier in the day's proceedings, the lead prosecuting counsel, Adegboyega Awomolo, SAAN, urged the court to foreclose Kanu's defense entirely. Awomolo reminded the court that the defendant had already utilized 5 of the 6 days allotted for his defense without calling a single witness or submitting any evidence. He noted that the court had previously adjourned to allow Kanu to enter his defense, or risk being deemed to have waived his right. Yet, the IPOB leader once again refused to proceed. The court on Tuesday adjourned till Wednesday for Kanu to enter a defense in his trial, or be deemed to have waived his right to do so. Awomolo argued, but when proceedings resumed, the defendant still declined to open his defense. According to the prosecution, Kanu maintained that there were no valid charges against him, a stance that has been at the center of his legal strategy since the case resumed. Awomolo therefore prayed the court to close the defense and fix a date for judgment, arguing that continued adjournments only serve to frustrate the trial. Kanu insists on no valid charge. Speaking from the dock, Kanu reiterated his long-held position that the charges brought against him are legally defective and unconstitutional. He insisted that there was no valid charge to warrant entering any defense, and maintained that the prosecution had failed to establish a proper legal basis for the case. This persistent argument follows a pattern of defiance that has characterized Kanu's approach since the Federal High Court dismissed his earlier no-case submission, a motion in which he sought to have the charges struck out without presenting a defense. Court cautions Kanu's former lawyers. In a related development, Justice Omotosho also issued a stern warning to Kanu's former legal representatives, P.A.N. Ejiofor, Aloy Ejimakor, Dr. Maxwell Opara, and Prince Mandela Umegburu, who now serve as his legal consultants. The judge cautioned them to adhere strictly to professional ethics, following complaints from the prosecution that they had been granting media interviews and posting commentary about the case on social media. Justice Omotosho emphasized that such public commentary could prejudice ongoing proceedings and undermine the integrity of the court, previous court directives, and adjournments. This latest adjournment comes after a series of similar directives issued by the same court. Earlier, on October 27th, the court had adjourned to November 4th directing Kanu to either file his final written address or proceed with his defense. However, when the matter came up, Kanu, who continues to represent himself in court, informed the judge that he had not filed any final written address as instructed. Instead, he told the court he had filed a new motion supported by an affidavit seeking to strike out all charges against him. The IPOB leader argued that the charges currently standing against him are a nullity ab initio, meaning void from the outset, due to what he described as the government's lack of legal foundation to prosecute him. New motion challenges the basis of the trial. According to court filings obtained by Sahara Reporters, the motion, titled Motion on Notice and Written Address in Support, was dated October 30th, 2025 and filed personally by Kanu. In it, he asked the court to strike out the charges in their entirety and order his immediate release from detention. The document cited multiple legal authorities, including sections 1,3, 6,6b, and 36,12 of the 1999 Constitution, as amended, as well as relevant provisions of the Evidence Act 2011 and the Terrorism, Prevention and Prohibition Act 2022. Kanu maintained that none of the charges against him were cognizable within the corpus juris of the Federal Republic of Nigeria, asserting that the government had failed to establish any recognizable offense under existing Nigerian law. The Federal High Court has now adjourned proceedings until November 7th, a date Justice Omotosho described as final and non-negotiable for the defendant to open his defense. Should Kanu fail to do so, the court is expected to close his case and proceed to deliver its final judgment in the long-drawn legal battle.